Welcome back to Elise Explains IP, where we take the big, messy, fascinating world of intellectual property and turn it into something you can actually use. I'm your host, Elise Dijkstra. Today, we're diving into one of Australia's most iconic food fights. And no, it's not about whether you keep the peanut butter in the fridge or the pantry. Seriously, who keeps it in the fridge? Gross. It's about Kraft versus Bega and the battle for the yellow peanut butter jar. Yes, the jar, not the recipe, not the name, the yellow-lidded jar. And the legal principles behind this dispute have enormous consequences for every business, whether you're selling peanut butter, software, skincare, or solar panels. So, let's get into it. Picture this. It's 2012. Kraft is happily running its peanut butter business in Australia. And if you grew up here, you could instantly visualize it. That bright yellow lid, the yellow label, the same jar your parents probably packed in your school lunch. Never oily, never dry. In branding terms, as what's called get-up or trade dress, the overall appearance and packaging that consumers instinctively associate with your business. Come 2012, Kraft splits its business. In the peanut butter side is assigned to a new company named Mondelez. A few years later, Mondelez decides peanut butter isn't their future, so they sell the entire peanut butter business, lock, stock and barrel, to Bega in 2017 for $460 million. That's a lot of peanuts. And when I say the entire business, I mean the factory in Port Melbourne, the recipe, the staff, and yes, the yellow jar get-up. Bega starts selling peanut butter in the same jar, but with a new label, and they run a campaign saying, same great recipe, new label. All good, right? Well, not for long. In 2018, Kraft decides, oops, actually we do want to sell peanut butter, which is now merged with Heinz, suddenly decides it does want back into the peanut butter market. So what do? They get Sanitarium to manufacture a new recipe for them and start selling peanut butter in, you guessed it, a yellow-lidded jar that looked almost identical to the one that they'd sold to Bega. You can imagine how well that went down with Bega. Bega sued, and the question became, who actually owned the iconic yellow jar? In 2019, the federal court and the full federal court in 2020 agreed that the yellow jar belonged to Bega. And the reasoning behind it is incredibly important for business owners to understand. Here are the key legal findings translated into plain English. Goodwill is an asset and it is powerful. Goodwill is basically the reputation or customer connection and brand loyalty that a business builds. The court confirmed that goodwill is a real asset. It can produce income, it can be sold, and it can be assigned. B. Each part of the business can have its own goodwill. If you run a business with multiple product lines, each line may have its own goodwill, its own identity, and its own customer connection. Each of these parts operate independently. So when Kraft sold only the peanut butter business to Bega, the goodwill for the peanut butter line went with it. C. Unregistered trademarks are a part of goodwill. The court confirmed that an unregistered trademark, including packaging and trade dress, can form part of goodwill of a business. In fact, it's the only way that they can be transferred. In Australia, you cannot transfer an unregistered trademark on its own. It can only be transferred with the goodwill of the underlying business that is also transferred. That means Kraft couldn't claim that the peanut butter jar stayed behind with the rest of the Kraft business because it had already sold the whole of the peanut butter division, goodwill and all, to Bega. So even if the business stays within the same corporate group, you can't shift an unregistered trademark from one entity to another without also assigning or shifting the goodwill of that part of the business. If you're considering moving a brand or an unregistered trademark into a holding company later, you may not be able to do that. You'll need to register it before you can do that. And this is where things often go wrong in restructures. There was a second claim. Kraft's new jars said loved since 1935. But remember, the recipe that had been used since 1935 was now owned by Bega. So Bega argued that Kraft's claim was misleading and deceptive under the Australian consumer law, and the court agreed. And that's why today Kraft's labels, when you can find them on the supermarket shelf, say the brand loved since 1935. A subtle but legally significant difference. So what should you take away from this, even if you don't sell peanut butter? This isn't just a quirky breakfast spread story. It's a blueprint for avoiding multi-million-dollar disasters in your own business. The first takeaway is to register your trademarks early, including your packaging. If your packaging is colours or shapes or has a distinctive label layout, you should consider registering them as a trademark. Unregistered rights create uncertainty, and sometimes, as Kraft learned, they can walk out the door with the goodwill, even when you didn't mean for that to happen. Number 2, before you sign anything, make sure you have identified the registered trademarks, any unregistered trademarks, get up and trade dress, and domain names, recipes, formulas and manuals, copyright and design rights, social media accounts, and of course the goodwill of a business. If you don't allocate it properly, ownership can be lost. The third takeaway is to be extremely careful with restructuring and IP holding companies. An IP holding company can be great, but only if the IP is transferred correctly. As you can see in this case, they didn't get it right. If you try to transfer an unregistered trademark without transferring the underlying goodwill, the transfer will be considered to be invalid, meaning you can lose the rights to register it later because you don't own it. The fourth takeaway is to check your packaging claims. Anything that looks like a promise to consumers must be factually correct, clear, and not misleading. So subtle wording can amount to deceptive conduct, even if you don't mean to be deceptive. The Kraft versus Bega case is a powerful reminder that IP isn't just the logo. Branding is more than what is registered. Goodwill is a real and transferable asset, and that small packaging details can be worth hundreds of millions of dollars. So next time you pick up a jar of your favourite breakfast spread, remember, the colour of the lid of a peanut butter jar sparked a decade-long IP war through the courts of Australia. If you're planning a restructure, buying a business, selling a business, or building your brand from scratch, make sure you get your IP house in order first. It's much easier and much cheaper than fighting about the yellow lid later. Thanks for listening. If you found this helpful, hit subscribe, leave me a review, or share this episode with somebody else who loves a good IP battle. My name is Elise Explains, and this has been Elise Explains IP. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to that friend that keeps borrowing other people's ideas. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me anytime. The link's in the description. Until next time, own your own ideas.